trial date. Everybody got their calendars handy?
Yes, Your Honor.
Okay, which do you want to address first?
Let's do the motion to dismiss.
Okay, fair enough then. Darcy, you got the calendar there handy?
I do.
How long before you guys will be ready to go?
With all due respect, Your Honor, I was going to suggest that we talk about the trial date first, because I think that will let us know. I know the motion to dismiss hearing is likely to have witnesses, so just in terms of timing, if we talk about the trial date first, I think that'll give us a better idea when we should do the motion to dismiss. But I'm open to either way, I just was throwing it out there.
Okay, any problem doing it that way, Lee?
Yeah. You want to do those? Yes. Yes, the motion should be determined first. Your Honor, we can be flexible, but it would make more sense to do the motion first.
Okay, all right.
Okay, well, I would like to do it on an off week for two reasons. One, it gives you the absolute time and we're not bunched up into our mess. I don't know if we'll be extending in July the off weeks. Okay, well, second reason is we can have a live court reporter on an off week because half of them will not be engaged. So, as early as July? June?
No, June.
Actually,
Your Honor, I think the defense had most of July and August marked off.
okay. So September?
September is the first month that we can do it, Your Honor.
Okay. Realistically speaking, how long before you're ready, Diane? You talking middle of September, the end of September?
I would say the end of September, given our commitments in July and August, Your Honor, if I'm being realistic.
Darcy, what's our open week at the end of September?
Well, we haven't extended that far in, but.
Well, David can tell you.
Is that the third week?
No, I think we're live the week of the 30th.
The week of the 22nd, we're unavailable.
The 20, that's the week of the 20th, isn't it? And the 27th or?
September 20th, let me see here.
Yes, the 20th, I'm sorry.
The 20th is the off week. Either the 6th or the 20th in September, or we can go October.
Does the week of the 20th not work for the state? I'm sorry, Lee, was that your point?
It does not work for us.
Okay, so then we need to go to October. Are the off weeks the 4th and the 18th, Your Honor?
4th and 18th.
Will we still be having off weeks at that point, Your Honor?
I don't know. I have to assume so, but I'm hoping that we don't.
Okay.
But that gives us also enough time to get a court reporter in here.
Because I was gonna ask the week of the 11th. The week of the 4th is not good for me, but
What about the week of the 18th?
I'm just trying to see, is that holiday weekend or the week of the 18th? Otherwise, one moment.
We have a holiday that week?
There's no holiday on the 11th.
No, they did away with the holiday on the 11th.
Okay, 1 second. I'm just trying to text with my co-counsel about dates. Okay, so just 1 second while I look at the calendar, Your Honor. How does like the 19th or 20th look, or 21st of October? I think. I'm sorry.
How many witnesses you guys going to try during that period? Because you'll have 9 to 5 with a break for lunch and 2 breaks during the day so the court reporter can stretch their fingers.
Yeah, I can't imagine more than 2 days being necessary.
Well, how many witnesses do you intend to call, do you know? Approximation, I realize.
Well, I would say 2 days worth, Your Honor.
Okay, and how many days you guys got, Chelsea?
So,
Okay.
sorry, I just had to mute, Lee. So I think what, I don't wanna like lie or
Oh,
would
no,
happen, but, I think that we need some insight on like the issues to be determined at this hearing, because just some insight from the court on that, because that will, give us information on like what witnesses we need and, kind of more information on the evidence we intend to present in rebuttal.
Chelsea, it's a motion to dismiss, that's the issue.
I hope that makes sense. I just want to have a realistic,
If they take 2 days, you would get 2 days. Tuesday, Wednesday, Thursday, Friday, if we need it. If we're done early, wonderful. Fair enough?
Can you hear me, everyone?
Yes.
I can hear Chelsea.
That sounds good for the defense, Your Honor. So the first day of the hearing would be the 19th?
The 19th, 20, 21, and 22 are all reserved.
Judge, I'm sorry, Chelsea's volume was not on, so you missed what was just said.
I said it would be the defense starting on the 18th and 19th. You guys would be the 20 and 21st.
Actually, it would be starting on Tuesday.
Yeah.
October 19th.
October 19th and 20th, defense, 21st and 22nd, state.
That works for the defense, Judge. If, as we realize it will be 1 day or less than 2, we would of course notify the court and opposing counsel.
Well, I'm going off the schedule right now. If we can adapt it to something shorter, fine. Okay, on the other hand, if we don't change the calendar, you're in the afternoon and you're done with your witnesses on the second day, I'm not gonna make them start until the next day, because I told them they had their 2 days.
Judge, can I raise some issues?
Yeah,
First of all, we submit that under Criminal Rule 12C, there shouldn't even be a motion hearing where the basic facts underlying the indictment are heard. I think this is really an abuse of the court's discretion to grant this hearing. But if the court wants to go ahead and have a hearing, of course, we have no choice. We're the tail, not the dog. But we don't have any expert witnesses revealed by the defense at this point. So we're going to need some other scheduling here. So we know what witnesses they're calling, what the subject matter is. Their motion to dismiss basically rests on the extrajudicial statements of the prior prosecutor, which is no notice to the state at all about what they're getting to. So, A, we think it's a mistake to hold this hearing, but B, we're going to need further scheduling and some orders as far as what they have to tell us before the hearing.
Diane?
Judge, like with any other hearing, if it was set in October, of course, we would give them a witness list, ample time, as well as if any expert were to testify, reports connected to that expert. We understand that. I think that's part of our discussion as to when the hearing will take place. I also think that there's been discussions, the number of counts that will be discussed when the hearing is held is obviously not an issue that is within our control. That's more within the state's control, clearly, Your Honor. And that could all shorten the time or the like. There's so many unknowns because things have been talked about and we're still where we are.
Okay, but the knowns I have is I have 25 counts. Okay, and you've got a motion to dismiss.
That's correct.
Now, I think it's at my discretion to have this hearing to make a record, okay? But
Please note our exception.
James raised her objection, that's fine. Ms. Grubb has raised her objection, I understand that. But if we're going through it, how long before you can get a disclosure to them?
When would the court like us to get a disclosure?
Friday? 2 weeks, 3 weeks?
From today, Your Honor?
That's what I'm asking, I'm trying to get something by agreement here.
Okay, and when you mean by disclosure, do you mean a witness list?
Witness list and reports if you got
Yeah.
them. They have to be supplemented as soon as you get them though.
I understand. I think we could get a witness list to the state by the end of the month, Your Honor. It's the 10th.
Okay, so by June 1st.
Okay? We'll have a witness list to the state by June 1st.
And Your Honor.
I assume you guys want 30 days after that to supplement yours?
Yes, at least, yeah.
Okay, so those 2 dates will be included in there. Ongoing furtherance, still in agreement? So if you get like a supplemental report, you have to disclose it as soon as you get it?
That's correct.
Agreeable?
Yeah. I mean,
Yes, Your
under
Honor.
motion, we have to do that anyway.
I'm just making sure we got it all aired out now. Okay, so does that get our first thing on our agenda?
Your Honor, I just had a couple of things that I was looking for clarification on with regard to the motion to dismiss, before we shift.
Okay, you're mumbled up. You're mumbled up, Chelsea. I can't understand.
Your Honor, can you hear me now? Can everybody hear me? Sorry about that.
Yes.
Okay, thank you. So, there are a couple questions I wanted to at least run by everybody before we switch to other case schedule discussions. So since your court, or Your Honor finds having a hearing on the motion to dismiss appropriate over our objection, I wanted to get some clarification on the basis for holding this hearing and the issues to be determined. I think that your order denying grand jury transcripts effectively denied some of the arguments that may be made pursuant to Criminal Rule 12. So I was just hoping maybe you could give us some insight about what issues you feel are still pending determination.
I have a motion to dismiss. I haven't prejudged it at all. Okay? Now, I went strictly by the law in denial of the transcript of the grand jury. I didn't see anything other than it being a fishing trip. Okay? But I still have the motion out there. So, and my basis for having the hearing is making the record accordingly. I think it's within my discretion, it's not an abuse of discretion, to hear testimony on the issue.
Your Honor, may I submit a suggestion that we have another deadline to submit any final addendums or memorandum with regard to that issue?
For what?
The proper legal basis to hold these hearings and the nature of what evidence or material may be looked at or considered by the judges.
Why is suddenly an issue a year later?
Yeah,
I've been
but
very open to everybody in this thing.
Our argument was detailed in both our reply and then included in our addendum. That was filed in conjunction with the motion for grand jury transcripts.
So you're not gonna add anything else?
I was just wondering what basis you're holding this hearing on, so that we could further clarify or explain if there's any confusion. Because it's my understanding that the pre-trial motion to dismiss an indictment that it isn't proper for a court to consider any evidentiary material. And it simply should be a consideration of the face of the indictment.
Anything else?
No, Your Honor, that's why I wanted to see if maybe there was what your specific basis was for requiring this hearing. See if maybe there was something we were missing, and just make sure we're on the same page.
Well, I think I can have the hearing. You know, I think it's based upon my power in controlling the motion play of the court. Okay, there is not a preclusion under Rule 12 on this, in my view. So that's where my thought pattern is. This is a case where I always left the record open for everybody. We're not hiding anything. There are severe allegations in the memorandum.
Yeah.
I think it's only fair that we deal with it. And the only way I know to deal with it is motion play. In this case, is by hearing. That's why I said it. That's why I thought we've had this problem from over a year now, and now we're sitting there fighting about it now. I've always said that motion hearing. I just
Your Honor,
Chelsea, can you turn off your other phone?
It is.
it
No,
is.
she's showing up. You need to log off so that it's not so much background noise.
Okay. Let me do that real quick. I'll just turn my computer on.
There you go. We have the rule.
Sorry about that. If there's anything that you didn't hear, I'm happy to repeat it if you'd like.
Diane, you want her to repeat what she said?
I don't, Your Honor. I think the court has made it clear that it's exercising its discretion, and for some time, we've known that this was going to be litigated at a hearing. So we're just setting a date.
If you want an entry from me so you can take it up interlocutory, saying that I denied your request to not have a hearing, I'd be more than glad to do that for you.
Your Honor, that
If you think I'm doing something wrong, I'll give you the right to the Court of Appeals.
Then, Your Honor, we would like that, if you could put your ruling into it.
We'll have it together for you.
Thank you, Your Honor.
Anything else on this part of our discussion? Okay, we'll be issuing an order relative to that part with all the timelines and everything on ahead of time.
Thank you, Your Honor.
Okay, now let's talk about a trial date.
I can get you this back.
Okay, trial date wise, what are you guys thinking? If we do that in October, it shouldn't take us long to get a decision on it. Could we be ready by the end of the year to try this thing, or are we gonna be forced to go to next year?
December, January is fine by us.
Yeah.
We've always been ready to go in January.
Yeah. I mean, we could have to do December as well, Your Honor.
I'm not bringing jurors in during Christmas for this.
No, and
I mean, let's be honest with here. I got responsibilities to everybody in this video, but I also have responsibility to the number of jurors I'm gonna have to bring in during the holidays. Really? No. We can do it the first of the year then. But I thought Jose had a problem with the first of the year.
Your Honor, I'm just circling back to October. If we were to have the motion to dismiss hearing in earlier October and the court ruled quickly on that, as it just indicated, would you be amenable to a late October date, and then we would be done with the trial by the Christmas, certainly depending on how many counts are being litigated, we could well be done before Thanksgiving.
Is that possible with you guys?
Yeah, the first thing that comes to mind is just that, to date, the state hasn't received any expert material or reports from, the defendant. So I think, you know, depending on when they can, produce that material to us, we want to, you know, speak to our experts or another expert about rebuttal.
October's out.
So I think that, October for the actual trial date would probably not be practical or realistic on our end.
So you guys had problems in scheduling the first half of October anyway, for the motion hearing? Because that week we suggested,
Yeah, so that was October 4th through 18th. That we
well,
were.
if I remember, the first of our availables in October, Lee couldn't do, Miss Bear couldn't do it because of commitments.
That was end of September.
Yeah, I believe she was free the first week of October, but it was the end of September that she was not available.
Could we do it in November?
It's not realistic to do it before January.
Huh? Okay.
Judge, I don't see how we can be ready before
Judge,
January, to be honest.
Judge, I'm a bit perplexed as to why we haven't heard an explanation as to why it's not doable before January. This case is not a new case. They're very familiar with what the legal and medical issues are. Having to hear their experts' response from our experts and taking longer than 5 months to do that really isn't a good explanation as to why Mr. Husel, who's been waiting for his day in court for so long, and we haven't given any pushback as to issues with the pandemic or things beyond everyone's control, but this is within someone's control. And the last team was ready to go, and this court was quite adamant that the election, but perhaps that we would not allow it to affect this case too much. I'm just, it's disturbing.
Judge, Mr. Baez owed us, and Ms. Menashe owed us expert reports January 1st of this year. And we haven't seen anything in the 5 months since then. So to flail us about not being ready is a little cheeky, I would say, because we don't have anything from them.
Well, if we had gotten
and we may not get anything from them for another whole month. And then we would be expected to go to trial in 4 months after that with the number of Marcy's Law hearing or Marcy's Law contacts that we have to make, and working with our experts again. I just think that's untenable. And the last time we talked about this, the trial was going to be in mid-22. We're good with it being in January. I think that's the best we can do.
Judge, forgive me if I sound cheeky for saying, when you take a man off the streets, you strip him of his way of feeding his family, and you call him a murderer before the entire state and slash country, that you might be a little bit more prepared to move forward on those accusations instead of waiting on what the defense might do.
Well, as soon as we get your experts, Jose, we might be in a position to have a better judgment on it.
Again, you just ignored everything I just said, but that's okay. We'll leave it at that and leave it up to the court to decide.
Well, if we go to January, Jose, you'd indicate you had a conflict last time we talked?
No, we didn't.
No, I did not, Judge.
Okay,
Your
you
Honor,
can do it in January?
wait, I'm sorry. Your Honor, it's me that has a conflict in January. I have a 10-day trial that is an 18 case with Judge Watson. It is a for sure go, and the reason why we have kicked it to the 18th is because there's over 20 witnesses that have to be flown in from Colombia and Guatemala that are state agents. So it's on, the 3-year docket in federal court. So That's just a non, and we've already had the Lafleur hearing, Your Honor, so, there is no plea.
Okay,
That's
is there possibility of February then? Will you be done with your trial?
I will be done with my trial in January, Your Honor, and it just begins the 18th.
Okay, so we're into February. Anybody got a problem in the month of February?
Not on our end, Your Honor.
I'm just curious though, if we were to get experts' reports to the government within the next 30 days, is their position that they still couldn't be ready in October? Because it seems to us to be ample time.
Any response?
Your Honor, I just think that when this case was previously scheduled for trial and also the previous motion hearing on the, regarding the pretrial dismissal, there were different scheduling, like deadlines with regard to the exchange of expert materials. And I would suggest that there's different case schedules for both the motion hearing and then the trial. So I think that since the motion to dismiss is at the end of October, I don't see how we could go to trial, and I guess.
Well, those aren't gonna be the same experts.
Right,
They're
but
not gonna be the same experts. We know that. Judge, I would be surprised if the experts that they use for the motion hearing on June 1st, that they reveal on June 1st for the motion hearing, would be the ones that they would be using for trial. So, I mean, maybe they will be, I don't know, but we have nothing. So, I mean, basically you're asking us, can we be ready to fly in October after this motion hearing when we literally have nothing?
But you have your
Okay.
pick. But you
Time
have
out.
your,
Time out. I'm gonna put an end to this conversation here. Here's the bottom line is I've got like 20 murders to try that are in jail that are ahead of Mr. Husel. Okay, so I got to jockey it around there. The better thing for me is to do it the first of the year. Because I don't want to go up there and I have somebody who wants to box under our priorities. They technically have the right to first go. So you're not my only murder case, folks.
Also, I think everybody's forgetting it takes time to get a voir dire of this size to be pulled in.
Yeah.
We're talking about months.
Well, I need 6 weeks to get the voir dire panel in. Let's get the subpoenas out. We probably need 2 weeks before that, so figure 2 months time minimum. Okay, just to organize. I gotta make sure that the availability's there. And, we still have to interact with the COVID rules because right now, I couldn't seat a jury of this size any which way. There's no way I can have enough manpower and enough space to quarantine the jury 6 feet apart, mask and everything, of the number that we have under the current indictment.
We may need to also set a time for jury questionnaires to go out to have enough time for that.
Well, Lee, I don't know if you were part of the conversation before. There's only so much space electronically we can do on the form. Okay? So we had to discuss if one, you guys could get an agreement as to a questionnaire. And two, if it's more than I think it was 35 questions, okay, then it would have to be done by paper, which they would have to do it of the day. There was no way we could get the paper out to them and assure that they got it.
Okay,
Plus,
I apologize.
I send out something that's inch thick to every potential juror. I mean, no one's going to show up. Now, I'd hope that you guys could get a questionnaire together. It's a beautiful tool. We can use our questionnaire and then you guys can do it by voir dire. But I thought this was a perfect case to use questionnaires because you can explore a lot of subject matter.
We're happy to make efforts in that realm, Judge.
Your Honor, Jimmy and I had made significant efforts in that way. I have a full jury questionnaire drafted that we had discussed together at length. So I'm happy to send that over to the state. We will.
Okay, send it over to Ms. Bear and Ms.
Okay.
Grubb. And then they can decide whether you guys need to talk more or whether it works.
Okay.
Because it's a beautiful tool. If I attach it electronically, it can't be more than 35 questions, I believe. Now, we had some progression in there, and I will check with our IT folks to see if we can expand it. Okay, but if it's more than the 35 questions, and that's even in parts, 35 parts of questions, okay, then, I don't want to get a question with 17 parts, because that's going to eat up 17 of the possible fields. Okay, so, we have 35. If it's more, I will have Darcy send an email out to you guys as soon as I find out.
Thank you.
Judge, just so I'm clear, and you're against doing like old school paper format, like we would in a death case?
I don't have any problem with the old school paper. I just won't send old school paper out ahead of time.
Okay.
Because if I send it out ahead of time, what's our attendance rate gonna be? If we pull a third on this, I'd be happy.
Okay.
So if it's paper, it can be live that morning. We'll give them a couple hours to fill it out, and then we'll start working.
And just that would be our preference. I think even just the COVID questions alone for jurors, and even though we're into 22, I still think it'll be relevant. So we'll get with the government, Your Honor, and flush it out.
Thank
Okay.
you.
So let's talk our February date. Because anything before then, guys, I know the state has murders out the yin yang. Okay, I imagine all the defense counsel do too. But I got people in jail, and I figured my rest of my year is going to be elbows and to murder cases all over the place. So can we start in February?
Works for us.
Now, I thought Jose wasn't coming, but I heard his voice.
Yes, sir.
He's here.
I'm here.
Stuck in on me, okay.
I did. I got finished with my other matter quickly, and I couldn't wait to jump on this one. Having said that, Judge, look, we're at the mercy of the court's calendar. We, of course, would like it in late October, but absent that, whatever the court thinks is the best course of action.
February, let's see. If we start bringing the jurors in the 3rd and 4th and start up on the 7th, with the actual voir dire, we'll do the preliminaries on the first 2, do it all on the record, cut out what we have, get a panel. I haven't determined a number yet, but I want it as a keep group. But at least we get through the issues of duration and those types of things in the first round, similar to what we do on a death case. And then work a solid voir dire starting on Monday. 7. Now, for those that don't know how I run my voir dire, you question the entire panel. Okay, we don't do monkey move up. Okay, it used to drive me crazy. Okay, challenges I usually do live, but this may be one. If everybody's in agreement, I do them out when the jurors outside the room. Any preference on that issue?
It's okay with that, Your
outside then?
Yes, please.
Okay, now, Sue Ann Robach, one of the past prosecutors, gave me hell on a murder case once about doing it that way. And her first question was, which is juror number 14? Okay, so you gotta remember who her players are, okay? But we can do it that way. We can do it that way. Okay, yes, ma'am.
We had 2 weeks in a row of Thursday, Friday. Previously. We anticipating just 1 week of Thursday, Friday.
Yeah, we had 2 weeks of Thursday, Fridays. She makes a valid point. That was the jury commissioner's request, so that would make it the Valentine's Day to start the actual voir dire. 3rd and 4th, 10 and 11 are jurors because of the count number. And if we reach my goal number out of the first thing, then we can cancel the second. Does that make sense? Can we start on Valentine's Day?
Why not?
That works for the state, Your Honor.
Ms. Menashe? Mr. Baez?
It's fine.
Fine.
Judge? Judge?
Yes.
Hi, it's Benita. What about President's Day? Isn't that typically that Monday?
It's the 21st.
Is it? Thank you. I didn't have no mark on my calendar. Okay, good.
Who was that? Oh, Benita. Okay. Hi, Benita.
Hi, Judge.
Okay.
21st.
Now, during the trial, I figured Monday through Thursday with Friday off. That's what we had talked about before. Is that okay with the state?
That works for us.
Because of the duration, I figured giving the jurors that extra break during the week would be beneficial.
Makes sense.
Now, the following week, when we have Monday off, we can go Thursday, Friday.
That works.
So we get 4 days a week of actual trial. And you have morning, noon, and night. I have to go back to the Supreme Court, get somebody to cover my docket, my normal docket. And we would just have access to this trial. Now I've got some logistics stuff to do. One, I might have to reserve the second floor because of the number that we'll have in voir dire. And then I gotta make, are those 2 weeks available to us?
Judge, are you talking about the 7th and the 14th?
The week, the 3, 4, 10, and 11, are those available dates for us to bring jurors in?
Yes, I don't see any reason why not. Correct.
Okay, we'll go ahead and reserve them out, and if we have to, we can cancel off the back end.
Sounds good.
Okay. Does that work for folks?
Yes.
Now, does anybody have anything set during the month of February that's problematic? I can either go talk to the judge. Huh?
The state is clear.
Okay. Mr. Baez, Ms. Menashe?
No, Your Honor.
Not here.
Okay. I'm not afraid to call another judge. I know some judges don't call other judges. If we need something pops up, let us know.
Sounds good.
Okay. Now, the jury instructions, I mean, they're gonna be standard pretty much. Except for, I anticipate an argument over the amounts and presumptions. Or is there an argument?
Your Honor, I think there'll be a number of jury instructions that we're apt to not agree on. But if the court wants to set a deadline for, proposing those that can jointly be agreed to, and then those that cannot, we're happy to meet that deadline.
Well, subject to any modification, if I was a lawyer trying this case, I'd want to know what instructions I was facing going in.
Oh, Your Honor, 100%. I figured that date would be sometime well in advance of the trial date.
Okay, maybe we can do that like in December. We won't require anything other than than the parties.
Absolutely. I
We
think
can
December-
arrange that.
December at the latest, in fact.
Because I'd want to know what I was dealing with instruction wise.
I think anytime after the motion to dismiss is ruled upon, we could get jury instructions over.
Okay? Fair enough then? Anything else I've forgotten, guys?
The only thing I want to clarify is we have the deadline for the experts for the motion to dismiss. Do we have an expert deadline for the defense in general?
I can rule on their motion for an extension, or you guys can get an agreement right now. I assume you want to enter an agreement right now, Diane?
Yes, Judge.
When can you have them over to them? Have you guys supplied all yours? Defense, I mean, state?
We have.
Okay, when can you get them over, Diane?
Ours were a year ago.
Well, I'm thinking we
I
have
figured
the,
that.
we have the experts' names and then any subsequent reports due on June 1st. I guess, Your Honor, I would, given that it's a February trial date, I don't know, end of August, September, Your Honor, July and August are particularly bad for all of us.
Is September 1 acceptable to the state?
For trial experts, yes.
For trial experts, yes. Which is why
Fair
the
enough,
October
Diane.
would have worked.
I mean, I'd like mid-September, but you know, I understand.
You want to go to mid-September, Lee?
I'd rather do September 1st. We turned over ours in March of 2020.
Okay, I know you'd rather. Are you willing to give her a break because of her trial schedule?
What date does she want?
Mid-September.
What date do you want exactly, Diane?
Mid-September is fine, Your Honor.
I'm pulling out my phone, Your Honor, so that I could look exactly at the month of September. September 17th is the second Friday in the month, Your Honor. I'd ask for that day.
We will agree.
Acceptable?
Yep.
Agreed? Okay,
Yes.
we'll put it in the order. So we'll grant your motion for extension, set it till September 17th. Okay. Now, I was thinking of in our jury panel, we would have the 12, plus I was thinking 6 alternates. Any problem with that concept? You think it's too many? The box will be not tight, but it may be difficult there. I'm hoping we're back to normal by then, but I'm not anticipating.
That seems reasonable, Your Honor.
I mean, we've all tried these long cases. You never know what's going to happen. I think I had 3 grandmothers die in the last one I tried. It was 4 weeks. So I'd rather have 6 and be safe.
I agree.
6 is fine, Your Honor.
Okay. Anything else for the good of the order then, folks?
Are we gonna pick a specific date on the jury instructions in December, or are we gonna wait on that?
Well, why don't we establish a date after we do the motion to dismiss, because I think, Diane, that'll dictate their pace on what they want to do.
Sounds
Is that
good.
fair, Diane?
That's fair, Your Honor. One last question with respect to peremptories. Do we need to litigate that issue, or do you already know in your mind, if we have 6 alternates, what's that look like for you?
Well, you got 4 and 4 outright. On the alternates, I'd probably give you 3 on top of it, but only in the alternate stage.
And then 4?
Well, standard's 4, right?
That's correct. I was just given the nature of the case. Yes.
Well, are you requesting more peremptories on both sides?
I'd like to discuss it with the case and see if they could agree with us on perhaps 6.
Conceptually, you guys want 6 peremptories on the main panel?
I'd like to at least discuss it, but we'll discuss it amongst council and I understand what the rule is, Your Honor.
We can discuss it and revisit, Your Honor.
Well, just the way I'm thinking, the rule applies, the alternates are my discretion. With the number of alternates, I was gonna give each side 3 on just the alternates. If you guys come up with something better you can live with, I can adapt.
Okay,
Okay?
thank you,
The whole
Judge.
idea is to have a fair trial. Now, if you guys want 20 apiece, forget it.
No, Judge.
Okay?
I think 3 for the alternates is perfect. I think the only thing is whether 4 could be expanded to 6, given the nature of the case. But again, we'll discuss with council and see if we can get somewhere. And if not,
Yeah, I'm willing to work with it.
then it's 4.
Yeah, if you guys can't get an agreement, it's gonna go by the rule.
Sounds good.
Okay? Anything else for the good of the order?
I think that's it.
Okay, now, Miss Darcy,
Yes.
anything you want to ask anybody? Since we're gonna be trying to crank this order out right away, and you type better than I do.
No, I think I've got it.
Is Miss Darcy Schaefer working as our middle person, been working for everybody?
Yes, she has, Your Honor.
She's a little bit more available than I am these days. But if there's any problems with her, let me know. Okay?
Thank you.
Anything else for the good of the order?
Nothing further from the state.
Nothing from the defense, Your Honor. Thank you.
Okay, I want to thank everybody. I apologize again for the mess up on Zoom. I don't know what happened. But for some reason, her account got dropped out of the system. So we did what we could. I'm glad everybody could attend. If there's any problems, let us know. We're open to everybody. I don't think anybody can complain about accessibility on this one. Okay?
Sounds good.
Hey, have a wonderful day.
Thank you. You too.
Judge,
Thank
you
you.
too.
How do I turn this off here?